Hello and welcome back to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the Nachman, Fawani, Zimochek, NPC Law Group law firm located in New Jersey with offices in Midtown Manhattan, and also we have an affiliated office in Canada and we have an affiliated office in Mumbai, India. So today I want to talk about a very basic concept in immigration law. It's called immigrant versus non-immigrant intent. And so oftentimes when I explain the concept between immigrant and non-immigrant intent, what I try to explain to our clients and potential clients is that there are two types of visas. There are non-immigrant visas. Those non-immigrant visas are basically temporary visas that allow an individual to come to the United States temporarily to perform certain types of services or to do a certain type of thing. And then, on the other side, there are what are called immigrant visas. And immigrant visas have associated with them permanent intent, or the intent to permanently immigrate to the United States. And so it's really important to understand these concepts and how they work together. Now, the other thing that's important to understand is that when you have non-immigrant visas, there are two types of non-immigrant visas. One type of non-immigrant visa is what we call a pure non-immigrant intent visa. So what is a pure non-immigrant intent visa? Well, that would be like, for example, a visitor's visa, or a business visitor's visa, or a student visa. And these visas are pure non-immigrant intent insofar as you must demonstrate when you get this visa to a U.S. consular officer abroad that your intention is to return to your home country after your temporary stay in the United States. And that's very important, because obviously what the officer is going to be looking for is they're going to be looking to see whether or not there's any intent by the individual, because everyone who is immigrating to the United States is presumed to have immigrant intent. And that's what Section 214B of the Immigration and Nationality Act says. So the idea is when you go to the U.S. consulate abroad, you have to go with sufficient proof when you're applying for a non-immigrant visa to be able to demonstrate that you don't have immigrant intent. So what kinds of things would that be? Well, for example, one of the things that a non-immigrant might want to, or a person who's trying to prove that they have non-immigrant intent, is that they want to bring proof of assets that they have in their home country. So that's one important proof that they're going to return to their home country, because there's a general rule that individuals who have assets in certain places will return to those assets. So for example, if you own a home in your home country, then of course the idea would be that you're going to return because you have your home there. Perhaps you own a car there, perhaps you have bank accounts there, perhaps you have other assets that would draw you back, maybe a pension plan that would draw you back to your home country. Other types of things that would be proof of non-immigrant intent might also be things like you have a job and you're taking a temporary break from that job to visit the United States with the intention later of returning to that job that's going to be held open to you. So what you may want to do is approach your employer to get a letter to say that the employer is aware that you have a full-time position, of course they offer it to you, and that you're going to be taking a temporary visit to the United States, and that you're going to be returning to that position that's going to be open to you at that place of employment. And there are other things that you can use. Oftentimes a letter from an individual in a social, political, or religious organization who is indicating that you are a member of that community and that you're going to be returning to take up that position within that community. So those are important things to demonstrate non-immigrant intent. Now, what many people need to know is that if you're applying for, let's say, a dual intent visa at the U.S. consulate. And what are the dual intent visas? Well, a dual intent visa is an H-1B for professional and specialty occupation workers, an L-1 for an intra-company transfer, an O visa for individuals with extraordinary ability, and those could be O-1As, which are individuals with extraordinary abilities in the arts, sciences, or business, or it could also be an O-1B, which is for an individual who is distinguished in their field of artistic ability, which can be, and we've covered this in another video, they could be singers, painters, etc., individuals who are known in their field of artistic endeavor. Also the P visa. The P visa is also a dual intent visa. So these visas, you don't need to show the proof that the individual has non-immigrant intent. It's certainly not hurtful if you go to the U.S. Consulate and you have that information, but the U.S. Consular officer should not delve into the issue of non-immigrant intent under 214B if you're applying for a dual intent classification. Now, one of the things where dual intent and immigrant intent come into play is that you have to be very careful to ensure that you aren't doing something on the immigrant visa side by way of an application or a petition which could potentially upset your ability to get, let's say, a pure non-immigrant intent visa. And where we see this happening as a problem, for example, might be where an individual is told that they're a foreign student, which is a pure non-immigrant intent type of visa, and then what happens is, let's say, an I-130 is filed by a family member on that individual's behalf, or a labor certification application is filed on their behalf. So what you have is you have a contradiction that's going on, because the individual, an employer or a family member, is applying for an immigrant visa classification while the individual is not in a dual intent classification. And that's where you have a conflict that arises. So our job as the legal professionals in the immigration arena is to be able to help our clients understand how to structure the case so there isn't a conflict in the underlying intent. So I just wanted to bring that particular issue to our viewers because we oftentimes get many questions about dual intent, non-immigrant intent, and also and also applying for the green card. So with that, we will follow up and have more and additional helpful information for all of you in the future. And thanks very much for tuning in, and we'll see you soon. Goodbye for now.